And I do apologise to him for ringing the bell in the middle. There's too many buttons for me here at the moment. I'll get myself organised. The question is that the motion be agreed to. I call the Honourable Judith Collins.
Mr Speaker, thank you for the opportunity to speak on this matter. The member resuming his seat, a former Attorney General, has raised some issues, and I'm not going to deal with all of them because some of them actually relate to issues that he's stated as fact, but also he's asked some questions about issues relating to the former Justice Wilson and my actions. I took this matter on the 19th of April this year when the Attorney General, the Honourable Christopher Finlayson, transferred this matter to me under Section 7 of the Constitution Act, and that later on I was actually granted a warrant to be the Acting Attorney General in relation specifically to this matter. At that stage, the Attorney General, the Honourable Christopher Finlayson, had already referred this matter through to the Judicial Conduct Commissioner. The Commissioner was already dealing with the matter, and he made a finding to me on the 7th of May recommending that I appoint a Judicial Conduct Panel under the Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004 to further investigate the complaints against Justice Wilson. I accepted that recommendation. At that stage, I'd received unsolicited submissions from many members of the, particularly QCs and SCs of the senior bar. I'd also received submissions from people who felt that they had been badly disadvantaged by the judges staying on the court when their matter was dealt with, and I took advice from the Solicitor General. The decision I made was that the matter should proceed and that I should in fact appoint a panel. This is the first time that this Act has been used, and it is the first time that we've come up against certain issues in it. For instance, when appointing the panel, I was not able to appoint an overseas judge to that panel. I was not able to try and bring some semblance that we had people from overseas who are not part of the judiciary in New Zealand or part of the New Zealand, senior bar. So that was an issue that I think is something that should be considered in future. I was one of the people who spoke against us getting rid of our right to appeal to Privy Council, and this was one of the reasons. The fact is, this is a very small senior bar in New Zealand, a very small judiciary, and great care needs to be taken in relation to any matters, and I support what the member who's just resumed his seat has said about great care needing to be taken in relation to appointments and into judges' behaviour. The matter itself was then, there was a judicial review brought by the former Justice Wilson, and in that, from the judicial review, a full bench of the High Court heard the review on the 1st to the 3rd of September, and they gave their judgment on the 28th of September. The Court noted that the Commissioner carried out an appropriate evaluative exercise in relation to the complaints, and it found that there was a legal basis upon which aspects of the judge's conduct might properly be the subject of inquiry by a panel. It also dismissed the judge's allegations concerning breach of natural justice and taking into account material that was hearsay or obtained in breach of confidence and legal privilege. The Court directed the Commissioner to conduct any further preliminary examination of the complaints that he considered necessary, to form an opinion under Section 15(1) in relation to the judge's conduct, including the period between the Supreme Court decisions, Saxby No. 1 and Saxby No. 2, and if recommending the appointment of a panel to the Acting Attorney General to identify the matters concerning the judge's alleged conduct that met the requirements of the Act. Mr Speaker, this must surely rank as one of the most worrying matters that the very new Supreme Court and the judiciary has had to deal with. It has been a very difficult time for the judiciary, and also, I believe, for the senior bar to have seen this matter progress. There's been some comment made about the settlement arrangements that I made on behalf of the people in relation to the former Justice Wilson. I'm happy to take full responsibility for those decisions, and I believe that those were the right decisions. I'm happy to speak to the House about how I came to those decisions. On the 4th of October this year, the Judges' Council approached the Solicitor General to discuss whether and on what terms the judge might tender his resignation. The terms offered by the former judge were extremely excessive, and I would not countenance them at all. I'm not prepared to reveal them at this stage, given that they were made in confidence, and I'd need to seek advice on that. However, I can tell you that they were absolutely excessive, and I would not take them further. However, after discussions, and there were many discussions, not with me and the former judge, because I did not meet the former judge, and I actually don't believe I've ever met in my life, and if I did, it didn't obviously leave an impression. He tendered his resignation on the 21st of October with effect from 5 p.m. on the 5th of November on the following terms: that he receive payment of his existing entitlements, and I'm sure nobody would disagree with that. That he receive payment of 1 year's salary, which is taxable, being $410,000 gross from the 5th of November. And I bore in mind when I agreed to that this matter could drag on for another 2 years or more. I was advised that there were something like 6 different appeal opportunities along the way. And despite the fact that there were all sorts of, at various times, suggestions that the judge might resign of his own accord, there seemed very little opportunity very little reality that would ever happen unless this matter was settled. It was not my intention to bring about the resignation of a judge. I think it is an extraordinarily difficult thing to have to oversee. However, the judge made this offer himself. It was not asked of him. We also had to agree to pay his solicitor-client costs, and like the Speaker who's resumed his seat, I thought they were very high. I was, however, informed that they were reasonable in the meaning of the word and in the meaning of what had gone on and the matter of proceedings. I was also fully aware that it is a constitutional principle that the Crown should meet at least part of the reasonable costs of counsel for a judge in complaints proceedings, and that I referred to Section 27 of the Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004, which made it very clear that it was expected that the judge's expenses would be paid. Of course, the Crown also has to meet its own costs in this matter, and the costs for judicial proceedings of this nature, if allowed to have continued, because I didn't feel able to accept the offer to resign that the judge made, could have been far more severe and had in my view, looked very much as though they would continue into stratospheric levels. I was not prepared to have that happen if there was an opportunity to cut the losses as such for the Crown and the taxpayer. I also noted that all the way through these proceedings, the judge would be entitled to be paid his full salary, even though he was in effect on garden leave. And I did not think that was a useful spend of the taxpayer money either. This has been an extraordinarily difficult time, as I have said. I, however, believe that I have made the right decision and that this matter had to be brought to an end. We have a very new Supreme Court. We have a court that is still is working very, very hard and is trying very, very solidly to build its reputation. It did not need this matter continuing. There's been comment made, I think not today, but certainly in the media, about, well, how will we know what actually happened? Will we ever find an end to this? Because if the Judicial Complaints Commissioner had been allowed to continue with his second report, this would all show it. Actually, as soon as the judge resigned, or the former judge